Thank you, Mr. Speaker. I move that the House concur in the Senate amendments to House Bill 2005B and repass the bill.
Representative Leiner moves that the House concur in the Senate amendments to House Bill 2005B and repass the bill. To your motion.
Thank you, Mr. Speaker. When the House passed 2005A in late March, we noted on the floor, I think Representative Hack and I both noted, that we wanted to work together to try to broaden support for the bill so that it could come through as a bill that both the worker advocate community and the employer advocate community and legislators from a wide range of perspectives could support, because fundamentally I think these are issues that we all believe are important. And in the last 6 weeks, we've done a lot of work to make that possible. I want to give special recognition to Senator Taylor, Senator Knope, Representative Hack, Family Forward, AOI, Association of University Women, Northwest Grocers, the trial lawyers, and Governor Brown, as well as Speaker Kotek and Majority Leader Williamson, to helping us find that path. And last week, this bill passed unanimously as amended by the Senate. So today we bring forward the bill on a concurrence motion, and I'm pleased to note that on your desks we have support letters from a really robust list of advocates from a wide range of perspectives. One letter has a lot of worker side advocates, and another letter has a lot of employer side advocates, and they really attest to the fact that this was a strong piece of teamwork. 90% of the bill is the same in my assessment. There are some important changes, however, that I want to highlight for you as I make this presentation on concurrence. One, the Senate added veterans as one of the protected classes. The bases on which you may lawfully have differentiated pay are clarified and narrowed to some extent. Most of the added protections are phased in 2019, and one set of protections for asking about pay history is phased in 2024. Punitive damages are available in an additional setting, that is for a repeat adjudicated offender. And a pay study, which was something that we focused quite a bit on in the last presentation on the House floor. A pay study is a useful tool, and I believe it's an important addition to this bill because it helps prevent discrimination on the front end, which all of us fundamentally, I think, want to do. We want to prevent the harm and the turmoil to both employer and worker that happens when there's a dispute like this. Importantly, there is a difference in how that happens from the version we considered last time through. A pay study that is relevant to the protected class at issue, where the plaintiff has already been made whole, can protect the employer not from back pay and attorney's fees, but from compensatory and punitive damages. So this revised version of the bill creates an incentive to do pay studies, and that incentive is not at the cost of a worker being made whole if in fact they've been discriminated against on the basis of pay. Also, two more things. If a worker decides to seek relief in a BOLI forum, Bureau of Labor and Industries forum, then the amount of time during which that suit is pending is an additional amount of recovery for back pay that the worker can potentially be eligible. And finally, there is a requirement to post these new rules at workplaces. This was the product of some tremendous teamwork from people who don't always see issues similarly, and I think it really, it was very heartwarming to me, and it was wonderful to be able to work with all of the people involved. And in addition to the folks I've already named, I want to thank Representative Holvey, who's been working on this issue for a long time, Kate Newhall, Trish Garner, Whitney Stark, Arthur Towers, Lori Cremona-Wagner, and Amanda Dalton and Betsy Earls, who did tremendous work trying to find a path forward. Also my staff colleagues, Mark Bond and Alan Van Vliet, because it takes a lot of people to move a complex policy like this forward. And I commend it to your attention and encourage you to give it your aye vote. Thank you. I want to add to the list of people who I want to give special recognition to in this process. Co-chiefs, the original co-chiefs, sponsors of the bill, Representatives Bynum and Lively. Thank you so much for your commitment to trying to make this evolve and develop into something that could earn broad support. I also want to note some legislative history for the record. The purpose of this bill and all the legislative changes that we have made in this bill are made with the intent to strengthen the ability of individuals to achieve equal pay and prevent discrimination in pay practices. And to the extent that there are ambiguities or conflicts of law as we have implemented this significant bunch of changes, the intent is for those to be interpreted in a way that enables workers to obtain justice and does not undermine existing provisions with respect to attorney's fees or punitive damages. And we would request that any conflict between interpretation of these amendments to ORS 652-220 and any other statute is interpreted separately and based on this legislative intent. Finally, with regard to work of comparable character, the legislature intends to maintain the broad interpretation applied previously by the Oregon courts, which recognizes that comparable character does not require exactly the same work, but rather work that has important common characteristics. Thank you.